I'm Antonio Romanucci, and this is another in our continuing series of cases and concept, and this one focuses on police conduct and how a so-called reasonable police officer should be acting under color of law under a given situation during an event or an encounter. Police misconduct cases often focus on an officer's conduct and whether their decisions were objectively reasonable, which means trying to define if their conduct may be what's called awful but lawful. This is a standard of behavior that was determined a generation ago in the 1980s by the Supreme Court of the United States. The court ruled that police use of force must be objectively reasonable, that an officer's actions were reasonable in light of the facts and circumstances confronting him without regard to underlying intent or motivation. The Supreme Court stated that reasonableness is not capable of precise definition or mechanical application. A number of factors require careful consideration before an officer can use force against the citizen. Some of the factors include, number one, whether the suspect poses an immediate threat to the officers or others, which means stand-byers. Two, the severity of the crime. Three, whether the suspect is actively resisting arrest. And four, whether the suspect is a flight risk or attempting to escape custody. For example, when police shoot an unarmed suspect, it's often ruled justified as long as the officer's fear of grave harm in that moment is reasonable. Let's say there's a nighttime foot chase. The suspect pulls out a cell phone, and officers mistake it for something else, and in a split-second decision, fire shots and injure or kill that person. When cases like this come to trial, jurors are asked to consider the facts as they are presented to the officers in the moment and not to use 20/20 hindsight or Monday morning quarterbacking. Courts have also decided that these incidents need not be viewed and judged from the officer's perspective of what is reasonable, not from the citizen's perspective. The question of reasonableness is one of objective reasonableness. The court will not look at the officer's subjective intent, but will only consider the circumstances the officer faced during the violation. But another factor related to reasonableness that is getting a lot of attention these days is the use of de-escalation tactics to avoid the use of deadly force whenever feasible. There are a multitude of options how to de-escalate a situation, and all police departments should have directives for their officers on how to throttle back the level of force used when someone no longer is resisting or is no longer a threat. This is a hard lesson for some officers to learn, and sometimes officers get caught up in the moment with tragic consequences. In those situations, other officers have a clear duty to intervene. One such situation where de-escalation tactics could have been greatly used and saved a life is the case of DeCynthia Clements, who was killed in March of 2018 because police officers failed to use de-escalation tactics, which could have saved her life. This tragedy took place near suburban Elgin, Illinois, in March of 2018. DeCynthia was known to police to have a mental health history, and when police pulled her over that day, she would not get out of the car. The situation became more intense when DeCynthia, holding what appeared to be a kitchen knife to her own neck, and later setting her vehicle on fire from inside the car. When she eventually got out of the car, she was tased and shot multiple times by officers before she died. There were many moments of opportunity before she died to intervene and de-escalate the intensity here, especially because she only appeared to be in danger to herself and not to officers. Clearly, had there been more communication between the officers as to what the plan should have been when DeCynthia exited the car, DeCynthia would be alive today. The only positive here is that these tragedies are receiving more and more attention by the media and the public. It is our hope that these tragedies are not in vain and lead to meaningful conversations and progress in policing policies and practices in the months and years to come, which become permanent and are a real serious attempt at saving life. For more information on police misconduct, please visit our website at rblaw.net. Thank you so much.